Welcome. Welcome to A Taste of Justice. I'm Professor Angela May Kupenda. And this semester, I'm posting on the First Amendment. I just want to tell you about something to watch for later. So this series is designed to just give some basic general information about the Constitution to the broader community, but also especially for my students who are studying remotely this semester. Now, we've been covering the basics of First Amendment law, but then in a few weeks, my students are going to have a 1 week long take-home examination, essay exam. Then they're going to write position statements on current First Amendment issues. It's going to be exciting. So they have to select an area, take a position, and to analyze the current conflict we're having based on First Amendment law. Then they'll make presentations in class, and I'll be coming here telling you about the topics that we have discussed on these current issues that I'm sure everyone is talking about, and we're just waiting to see what will be the resolutions. For today, though, we have a few more topics to add to our knowledge about the First Amendment. Today, I'm going to talk with you about access to trials and the First Amendment. Now, if you're like me, sometimes you may wonder, would it be better if a trial was more private, like a courtroom involving either a criminal case or involving a civil case? Sometimes there's so much going on in these cases with the media, with other individuals who are present. Some of the matters may be about very personal matters, and you may wonder, why are the trials open? So today, we're going to look at the First Amendment and why these trials are deemed to be open generally, and what purpose does it serve in terms of the First Amendment. Now, before I get started, I want to do my spiel that the court has many cases and interpretations about the First Amendment. I'm here giving you my explanations. These explanations are my own and not to be ascribed to my school or to my students. For informational purposes, I'm a professor at Mississippi College School of Law, and I've been teaching for about 30 years. Okay, now, access to trial. So I have 3 questions for you. And then we're going to go through after each question and comment. So the first question is this. I don't know if you've ever been a party in a trial or in a case, whether a civil case for monetary damages or for a criminal case, or a witness in such a case, or a member of the media. So if you were a party in a trial, the plaintiff or the defendant or what have you, or just a member of the public concerned or the media, what would you rather? Would you rather for the judge to have just a wide open courtroom? You have the press all over, you have people with cameras all in the faces of the jurors to get the expressions that are made when various testimony comes forward. You have the jury and the parties, you have the press and members of the public stopping them in the hallway, wanting to hear their take on the trial even before they can fully deliberate. Do you think that would be best, just a wide open courtroom? Or would it be better for a judge to say, look, this is a serious matter. We're going to only allow the parties and their attorneys and the jurors and what have you in the courtroom, no other people from the public, no other media. So which do you think is best, the wide open or closed? Well, the court has said neither. In the first situation with the wide open courtroom, and I've given you a name of a case in the bottom in the text box, the court said in Shepard versus Maxwell, the court said it was like a Roman holiday, whatever that means. The court said the judge did not do enough to control things. This was about bringing about justice, and the judge could have taken some steps to have a more controlled setting. But in the other case, Nebraska Press versus Stewart, the court said the judge went too far. The judge went too far in denying access to the courtroom. So here, the court is saying that just wide open, whatever, is not good. But on the other hand, a very controlled setting that limits access is also considered to be not good, and that it is the job of the judge in order to have access, but also to remember the purpose for which they are in the courtroom. Okay, let me give you another one. Let's say a news reporter has a confidential source and the information turns out to have been correct. So in a given case, a judge wants to compel this reporter to release the name, to give the name of their confidential source. So what do you think? In the name of justice, can the reporter be jailed until the source's name is revealed? Or in the name of the First Amendment, can the reporter claim that the name is privileged information? And can the reporter say that the reporter has a right not to speak? What do you think? Well, I've given you, like you've seen a television show about this, I'm sure. I've given you the name of a case at the bottom, Brandsburg versus Hayes. But that case really doesn't, it helps, but it really doesn't answer all of the questions in terms of what advice we would give to a reporter. The court held in that case that a reporter does not have an absolute privilege, not absolute where they receive the questions or the summons or what have you from the court, they just can't ignore it. It is not an absolute privilege. But on the other hand, there, in that opinion, there was a justice who kind of sort of stood in the middle, and he said you have to look at a number of things. You have to look at good faith. You have to weigh the interest. You have to weigh the value of the testimony. You have to weigh all of these factors. And sometimes the reporter ought to have this privilege. So the courts went many different ways in resolving this issue. And now I was doing some research. Many states, maybe half of our states, have some kind of state law that gives protection to reporters to some degree to decline to give the name of their source. So the answer to this question I will have to answer is not clear to me, but I have given you the name of the case and you can check it out. And you can also Google, and I'm sure you'll find a lot of the same information I did, that in various states, there are various rules in terms of the privileges a reporter may assert. Okay, let me give you another one. You're like, what is that? Let me go back. You're thinking, she didn't have an answer for us. Oh, the law is amazing. The law is simply amazing. And I've been teaching long enough to know that there are some things that there simply is not really a definitive answer for yet. And it's okay to say so. Look, you keep subscribing though. Do not unsubscribe because I didn't have that answer. Now, let me give you another one. What if there is a murder trial and there have been just a number of mistrials, and some may be about leaked information and what have you? And so the defendant, the criminal defendant, just wants it to be over. And the prosecutor, the state, feels the same way. So the criminal defendant and the attorney and the prosecutor, they both agree that the trial should be completely closed to avoid leaks of information and further mistrials. So a newspaper actually filed suit. The newspaper is not a party to the case, but the newspaper, like, you can't shut us out, and file suit. What result do you think? Can the parties to a case completely close the case? Well, the case is Richmond versus Virginia. And the court said that trials are presumptively open. Now, there are some cases, depending on the nature of the case, depending on who the witnesses are, there may be certain steps that are taken to have a closure or closure in part. But the presumption is that a trial should be open. Then it's up to the judge to determine what does that mean, how many members can be allowed, how many people from the public can be allowed in, what about the media, et cetera, how to maintain control, what steps to maintain control. So why are trials presumptively open? This is not a criminal procedure class. This is not civil procedure or trial practice. So why are we talking about trials being presumptively open? Well, it's a First Amendment issue. It really is. And this newspaper brought suit. The court said that having an open trial serves a number of purposes. For one, it helps with community concern and emotions. There may be a case, a criminal case or a civil case, where people in the community are really upset or angry or distressed about what has happened. Having an open trial where they can see the evidence for themselves. They can see how the jury maybe reached a given conclusion can help in terms of their concerns about whether justice was done for the community. The court also said, some of the justices said, that trials have been traditionally open and that there's a right of access under the First Amendment for the public and for the media. In addition, one of the justices talked about, going back to a case, New York Times versus Sullivan, perhaps, or maybe the Gertz versus Welch, dealing with defamation. The court talked about wide open, robust debate. So one of the justices said that in order to have this debate, in order to have public debate needs to be informed. And in order to have informed debate about an ongoing case, access to the trial by the public and by the media is critical. Now, you may say, well, what? Everyone can't come in. The courtroom is not that big, right? And the court said, right. A judge, of course, may impose reasonable limits, reasonable. Remember, we talked about that space in the middle, content neutral, reasonable time, place, and manner regulations, reasonable limits in terms of the access, in terms of access to a testimony in person or by video, what have you. They can impose reasonable limits to control the environment. But then one of the justices said, even though you can impose reasonable limits, you cannot completely eliminate the media, because the First Amendment, remember, also includes the press, that it serves a purpose to communicate information to help the people to be informed. Oh, wow. Read about these cases and think about them for yourselves. In the text box below, I've given you the name of the cases. Look, learning is just so important. Learning can help us to be more enlightened and to be more thoughtful people and citizens and persons in the US. And this enlightenment can lead to greater freedom, and freedom can lead us to more justice in our society, justice for all. So subscribe and sign up for notifications, and I will see you next time.